Well, hello there. How is everyone? I hope you're all well on this terrific Tuesday. I thought it was Wednesday there for a minute. I thought it was Wednesday, but no, it's terrific Tuesday. And do you know what else is terrific? You are. You're looking absolutely terrific, I may add. And I hope you have a terrific day to go with it. But in today's video, we are just talking about some new documents that have gone up in the Idaho 4 case. First one is with regards to the state's refusal to add more, or how can I say, is to change the deadline dates in the Idaho 4 case. What it would appear is that what the state is saying is that some of the dates that Ann Taylor had requested as deadlines for paperwork to come in or documentation would mean that it would push beyond the boundary of a March 3rd trial. Let me just get it up here. I'll show it on the screen. So it's basically saying that, as the record reflects, when the parties appeared before the court on Wednesday, February 2024, discussion was had regarding schedule and orders and trial dates. Both the state and the court indicated interest in a March 3rd, 2025 trial date. I thought that they were more pushing towards the summer, but we'll go with this. The state also proceeded to outline a list of proposed pre-trial deadlines. The court then asked for the state to submit the proposals to the court, which the state did by letter dated February 28, 2024, a copy of which is attached. Exhibit A. The state's proposed deadlines would accommodate the March 3rd, 2025 trial date. The additional deadlines proposed in the defendant's March 6, 2024 filing would negate the possibility of a March 3rd, 2025 trial date. Because of this and for the reasons previously articulated in our filings and in court, the state objects to the defendant's March 6, 2024 motion requesting additional deadlines and resubmits a March 3rd, 2025 trial date with pre-trial deadlines as outlined in Exhibit A is appropriate. So I do hope that this will push to allow for an earlier trial. I certainly do. I just feel that if this is the case, then both sides need to do what they need to do to get it done. That's the prosecution. Certainly, they haven't been forthcoming with their documents. Certainly, Ann Taylor has had to request discovery multiple times, which we know. And if the state now seem to be angling towards an earlier trial, which again I feel is good, we've questioned whether they feel that they've got a strong case and why is this being delayed. But I don't know whether this is reactive, because they now know that in the media they are now being called out and that people are it's starting to gain momentum that perhaps it's not just Ann Taylor and Brian Kohberger who are delaying things, but it is in fact just as much the prosecution who are helping that scenario. So look, hopefully we get a March 2025 trial date. It's definitely not going to happen before that, so we're not going to see anything happen really this year. But there is something else bubbling in the background, which brings me to the next document. This is the interesting one. Now, we heard in the court, obviously, that it would appear that Brian Kohberger was approaching the Supreme Court for appeal. Now, there's going to be multiple feelings about that. We've known how his appeals have gone in the past. Is there likely to be an appeal? Is it going to get? I genuinely don't think so. I don't know. It depends what case he can put forward to the Supreme Court and what evidence that they can show to support their approach. But generally, these things seldom go in the way that a defendant wants them to go, and the likelihood, so don't anybody think that this is likely to go any other way. I think if it does, then hopefully if there is an appeal and it's warranted, then that's good, and perhaps it is just to go back to a preliminary hearing and we go down the track properly, and we go down the track in a different manner than we've seen at the first time round. But who knows? But this is what this document says. It says, come now, Brian C. Koberger, by and through his attorney, Ann C. Taylor, public defender, and hereby moves the court for an order to seal the defendant's motion. This is the motion to seal the augment. So he filed... it is hereby ordered the defendant's motion to augment the record shall be sealed. So he basically filed a motion to augment the record. Now, what that actually means is when there is an appeal set forward, if they feel that something is missing that needs to be shown in order to support their approach for appeal, then they have the ability to request that information. Now, that could be anything. That could be the exculpatory evidence, perhaps, because we have heard that there is stuff being potentially hidden by the prosecution from Bethany Funk. That would seem to be the case. It may be that they are after additional IGG documentation. This might be a way that Ann Taylor is trying to angle to force to get certain records that she feel are being perhaps delayed. This could be further car information. People said, or I've seen in comments, a lot of people have said maybe Ann Taylor, there's cameras everywhere. There's cameras absolutely everywhere. You only have to catch Brian Koberger at a stoplight or something like that at a time that coincides with when they're saying this crime took place. And if Brian Koberger was driving around, then surely there will be evidence of him driving around somewhere, unless he was literally driving around where there was absolutely no cameras anywhere at all. Do you know what I mean? So we don't know whether Ann Taylor is looking to seek out other information that they have, the prosecution have, that could support his alibi to say that he was somewhere else and not in Moscow, Idaho at the time of the crime. We don't know, but they are the current docs, like I say. So the augment of the record in terms of requesting additional documentation to support an appeal going towards Supreme Court, and obviously the fact that the state are refusing to offer specific dates for the deadlines because they want to push the trial forward, which I think is a good thing. Let me know down below what you think. Is it a good thing? Is it good to get this trial going quickly? I know there's going to be a lot of people who want this trial to go as quickly as possible. They want it here. We all want to know what happened. We always, in the public, we're like sponges, aren't we? We want all that information. We want to know what's going on. We want to know. And JB Gunner said yesterday, or I don't think the video, I watched it yesterday, he was saying we're not entitled to it. You know, we're quite entitled people. We think that people owe us something. They don't owe us anything. But I think what they do owe, especially the court system owes, is transparency to the public. So when they're doing something, then the public should be shown that what is being done right, so they can trust the system. I did a video yesterday where someone who was working in forensics in Colorado had been manipulating DNA results, it would appear, for the best part of 30 years. Now, they haven't come out and said how many people that's affected yet and in what way that's affected them, but there's things like that. That has decimated that now. You know, how is that system and how is Colorado going to pull themselves out of what, well, that's if people see it. That's a big thing, isn't it? The fact that many people don't even get to see these things because mainstream media won't push it out and they won't talk about the importance of it, I don't think, and what and the impact that can have on the general public. But anyway, that's the court docs, that's it. I hope you all have a fantastic day, and I will catch you a bit later in video 2.